Thank you for joining us today. I am very excited to introduce you to Roy Baharad, who's an associate professor at the Faculty of Law at the Hebrew University in Jerusalem, and Meir Yarom, who is on the Buchmann Faculty of Law in Tel Aviv. They're presenting a paper that is on a topic that's particularly near and dear to my heart, which is both political theory and insurance. And it's also a work in progress, which is the kind of thing that we cherish here. And so I've said this before, but I'll repeat it now. If anyone in the audience is aware of any works in progress that have to do with insurance law, please let us know. We're always looking for papers at that stage of development. It's just so much more fun to engage with them and the authors and feel like you kind of have a stake in where it's going. So with that, I'll hand it over to Roy. You want to take the mic?
Sure. Can you hear me all?
Yes.
Okay. So thanks, Travis and Peter, for the invitation. This is a joint work with Meir, who is here. I'll start presenting the basic idea, the basic insight. Then Meir will take over for the legal theory part to make sure that I'm not making complete fool of myself. And then I'll take over again to discuss some application to insurance, and then we'll open the discussion for Q&A, which would be way more interesting. Okay, so I'll just start talking then. You can all see the slides, right? Great. So insurance, very broadly stated, and to completely generalized. We have two main approaches. We have the traditional approach to insurance that views this as a basically market mechanism for risk distribution, and then we have the more modern approaches. You can see Tom here, Tom Baker is a pioneer in this regard that basically perceives insurance as much more than the narrow view of risk distribution, more discussing its governance role or regulatory role, how insurance serves as a social institution that basically reduces risk and disciplines policyholders, and prevents moral hazard, and overall keeps our society sufficiently or keeps insured sufficiently prudent. And our contribution, I think it is at once aspirational and modest, because we tend to offer a new view and a new outlook, a novel approach that spotlights the political role of insurance. And our argument here is that insurance is not only a social institution, it actually performs substantial and incredibly valuable, but thus far overlooked political roles and political functions, and fulfills political goals. And our paper makes two main claims. First is what insurance does. And we argue that what insurance does is that it creates basically practical meaning. It affords a practical meaning of legal norms. And we'll discuss the important implications for jurisprudence and for legal theory more broadly. And then our second claim is that how it does that matters a great deal. So we think that our approach, our argument says that insurance performs that. It performs its role as the creator of legal norms in a way that makes it a very close approximation of direct democracy. And let's dive right into the first argument and the jurisprudential background. And this where May will take over. I'll throw this hot potato to May because he's way more he's well oriented in this regard. So May, go ahead.
Thank you, Roy, and thank you everyone for having us. It's as I said, it's a pleasure to be here. So what I want to do in the next couple of minutes is firstly to introduce you to the two actual problems that we're trying to tackle in this paper, because we say some things about them, but we don't really introduce context about them, and it's important to understand why they're so meaningful in jurisprudential discussion. So the first thing to note is that virtually all legal philosophers, especially legal philosophers from the positivistic persuasion or school, believe that the law not only guides, but that it has to guide, right? It's an essential tenet of the law that people can obey it, that people do obey it. For otherwise, we can't really explain in what sense we have a functioning, a responsive legal system. So that's kind of the broad context in which we're talking. The problem is that it's not really easy either to explain precisely what guidance by law means, on the one hand, nor to explain how subjects can obey legal rules and can obey legal rules in a way that preserves core positivistic assumptions or commitments, right? So that's the complication. So let's dive right in. As you can see, the first bullet point is the Hart's famous distinction of rules and versus standards. Actually, it's not Hart's per se, but Hart really has made a big deal of that. It has also been around since at least Hart and Zaks in the legal process school and so on. But really, Hart kind of owned it in his seminal concept of law, his book, of course, 1961. And the starting point here is that Hart argued, we think convincingly, that there are certain problems that impede our ability to guide and be guided by the law. And we want to briefly lay bare these problems. The first is that legal language usually is general. We don't talk to individuals, right? When we codify, when we issue legal directives and so on. We don't say, Peter, do that, or Meir, do that, and so on. We talk to classes of people. So that's one thing. The other thing is that we don't usually say, look, if X and then A, so do Y in the particularized sense. Rather, we say that in the universal sense. We use action tokens, right? Don't steal. Theft is unallowed, and so on. And these generalizations mean that the legal language is necessarily to an extent obscure. Okay, so that's the first problem. The second is that we also, by virtue of being human beings, don't necessarily know and cannot foresee each and every contingency of whatever cases we are looking forward to regulate. So at the point of legislation or norm enactment, we can say usually with a broad brush what we would like to happen, but oftentimes trade-offs, circumstances, and so on change dramatically between cases, even within the same legal area, which means that what we have is indeterminacy of fact. This is how Hart called it. And this leads to the following and last final ambiguity, namely indeterminacy of aim. Because we can't necessarily specify each and every foreseeable or rather unforeseeable circumstance, what happens is that we don't really know for each and every case of application of a general legal rule precisely how we would want to resolve the issue, right? So we can say, look, killing is wrong, but self-defense has to be objective rather than subjective, but objectivity, and so on and so forth. So making these value judgments or trade-offs between values and between circumstances and so on is a very difficult thing. Hart argued, and again, we agree. And the upshot of all of this analysis is that it becomes quite costly to legislate crisp rules that actually specify ahead of action what kind of concrete behavior is demanded from the legal subject, right? That's the preliminary problem. So this gives rise, of course, to the distinction between rules and standards, whereas rules usually denote very particular modes of behavior, or at least relatively particular, namely, don't drive in a speed that's over 55 miles per hour. Standards are, of course, more lax. They tell you to drive reasonably or carefully or not aggressively, and so on. Now, the use of standards, way more abstract, more general, and hence less determinate legal norms, creates two problems for positivistic theory. We are, of course, not the first ones to notice that, but we want to put them in the specific light that is relevant to us. The first problem is that I began by saying that positivists agree that the law must be able to guide behavior. But as Jeremy Waldron argued, legal guidance is not equivalent to simply galvanizing action by any means necessary, right? So if I threat you or if I scream a command at you, this would not amount to normative guidance, right? Because the more ambiguous the norm, the less the subject is able to ascertain exactly what's required of them. And here is when the standard becomes problematic, because at this point, what happens is that subjects do not really have a crisp ex ante knowledge, and therefore their ability to plan ahead is to that extent undermined. So if legal guidance, as Waldron argued, must be normative, if it must bear on the practical reasoning of subjects to that extent have to have this ex ante knowledge, we claim that the more standard-based the system is, the less such actual guidance can occur. So not only is that a problem, by the way, of the actual guidance, note that this is also a problem in another sense for the normativity of guidance, because it seems to be unrespectful towards citizens. It doesn't allow them really to plan ahead, and it seems to kind of, I wouldn't say bypass, but perhaps overlook or not take sufficiently seriously the rational capacity and autonomy qua agents that are responsible for their actions. So that's the first practical problem, namely the impossibility of guidance qua normative legal guidance. The second problem is conceptual. Now, this is a point that comes back quite often recently in jurisprudence, for instance, in David Eisenhauser's book, to which we refer. The problem is this: Hart's claim against Austin, or one of his more important claims against Austin, is that Austin, on the one hand, needs to supply some kind of account, provide some kind of account of how people are guided by law, but on the other hand, Austin does that by reducing legal guidance to simple sociological empirical premises. Namely, look, there's a sovereign, the sovereign is powerful, he enjoys a habit of obedience because he threatens sanctions. To the extent that people follow the rules because of sanctions, we have guidance. Hart's response to that, as we show in the paper, was that this cannot really do justice to guidance by law because this is not a normative picture. What happens here, Hart thought, is that Austin essentially equates the law with the gunman writ large situation, but the law doesn't operate that way. And what Hart wants to say is that it is the internal point of view, which we show as explicated by Waldron as well, which must be accounted for, namely the legal subject's ability to integrate the reasons that are encased in the legal rule and so make a rational decision whether and precisely how they obey. Whereas Austin thought that as long as subjects fear sanctions, they will follow the law, and that's enough, that's all that legal theory needs to say, Hart sought a normative account of guidance and cannot make do with subject being bullied or manipulated into obeying legal rules. So the corollary of that second line of problem is that we must show that subjects obey because they weigh the relevant reasons, because they have in some way practically engaged with the legal rule, but we must do so without jeopardizing the distinction between law and morality. So we are not allowed, on Hart's methodology, to say people endorse this legal rule because they morally endorse it, because it is a morally good rule to have, and so on, because this would, for Hart, defy the distinction between law and morals. So here we reach the second problem, namely that we must locate some subset of reasons that are not necessarily or inherently moralized reasons on the one hand, but that cannot be reduced to sheer coercion or brute force, namely to reduce Hart to Austin. So these are the two problems that we're trying to tackle. And our argument, and here I'll throw it back to Roy, is that insurance deals with both problems. On the one hand, practically, it rulifies standards and affords them concrete meaning, which on this account, allows Hart to secure guidance, or at least to secure guidance better than a standard-based model. And secondly, conceptually, it does so through markets, which necessarily, we argue, or in equilibrium at least we argue, display a participatory process. And again, this secures acceptance because subjects now become or turn from passive objects which merely need to acquiesce in whatever concretization of norms officials undertake. Now subjects become actual stakeholders negotiating, at least to some extent, the terms governing their behavior. So I'll stop here, and please go ahead.
Thanks, Meir. Can you hear me again, right? Fantastic. So here's a very stylized example that simply illustrates how insurers first rulify standards into concrete rules in a way that that secures guidance, and conceptually how they do so in a way that how basically they allow market norms to dictate the outcome in a way that secures acceptance. So here's a like very stylized hypothetical example. Suppose that we have some town, and within this town we have a lawmaker that is quite reluctant to specify the exact speed limit. So what the lawmaker says is drive reasonably. Again, this as a result, we have both jurisprudential problems that Meir talked about. They're now resurfacing, right? First, where's the guidance in this regard? And second, how can we even discuss acceptance in the acceptance of, such legal standards? And we try to argue, let's think of what happens subsequently. Subsequently, we have demand for liability insurance. We have demand that for clarity vis-a-vis the norms that apply. Now, here's the interesting mechanism. Here's what happens. Liability insurance sets the price of insurance. Note, importantly, insurance is a product that whose price is twofold. You pay with premium and you pay with behavior, with required behavior, with the terms basically of the policy. So you're excluded from coverage if you exceed 38 miles per hour. This is the price of insurance along with my premium. Now, first, and we see that immediately the reasonableness standard, turns into a 38 miles per hour limitation. It turns into a rule. So in this regard, insurance immediately provides guidance, right? Because it takes the opaque, the abstract, the open-ended legal standards and translates it into concrete legal norms as a prerequisite for coverage. Now, second, and this is here's how we deal with acceptance. Why exactly 38 miles per hour? And here's interesting. The simple and interesting answer here is that well, this is market equilibrium. What do we mean by that? At first, if the requirement were to say too lax, so too lenient, say you can. Oh, I'm sorry, too strict. Say you can say you can drive only 20 miles per hour is a prerequisite for being covered. So meaning that if you drive 21, 22, 30 miles per hour, then you're excluded from coverage. In that case, drivers would simply shift to competitors or avoid insurance altogether. So in this regard, the insurance fails to maximize profits. Now, take the other extreme. If the requirement were too lenient or too lax, say you may drive 50 miles per hour and you're still good and you're still covered. In that case, the insurer would simply pay for substantial realized losses and again fail to maximize profits. In the other extreme, and the result is that in competitive equilibrium, we have a reflection, we have a norm that actually reflects some kind of preference aggregation that accounts for risk tolerance. by the relevant the risk tolerance, of the relevant population, namely of the insureds, of potential policyholders. So, and the move here, the analytical move here, is that when we have an aggregation of individual preference, this is actually a proxy for direct democracy. Think of a hypothetical scenario where all individuals congregate and attempt to vote on exactly the norm that would apply. This is this is equivalent. This is the norm that will emerge, the concrete norm, the rule that will emerge, would ultimately reflect their actual preference their preference for losses versus flexibility, meaning their risk tolerance. Now, a rule determined democratically, i.e., so in response to subjects' preferences, rather than top-down ordinance, the gunman writ large of Austin that Meir talked about, satisfied the broad, at least the broad notion, and we'll discuss momentarily what we mean by broad notion of the Hartian acceptance. And in this way, the rulification not only allows for guidance, which is perhaps the more straightforward move that we have here, but also it secures acceptance in its broader sense, and therefore we also have a concrete workable norms that actually emanates from subjects' preferences. Now, we have actual examples from practice. We discussed two of them. And first is cyber insurance, cyber liability insurance. By the way, side note, we discussed liability insurance here. We can discuss that in the Q&A. The reason we focus on liability insurance is that liability insurance is the bridge between standards and rules, in that when my liability, my legal liability vis-a-vis third parties is uncertain, this is where insurance this is where the insurance as an institution becomes relevant as a proxy for these direct democracies, as a rulifier of the relevant standard. Now, with cyber insurance, it's always about reasonable data security. And what's interesting is that we see the actual dynamic, we saw the actual dynamics in this market, the dynamics we discussed previously. So at first, multi-factor authentication was basically a prerequisite for coverage, which is equivalent to saying drive 20 miles per hour, otherwise you are uncovered no matter what. The thing is that unsupplied demand remained in the market. Potential insureds that work with legacy systems, with obsolete systems, for which MFA is unworkable, but they still wanted coverage. And the market reacted by simply admitting compensating control measures in lieu of MFA, and thus expanded, basically moved from the strictest possible standard into a more lenient one, in order to cater the needs and supply this previously unsupplied demand. So the convergence into equilibrium here actually reflects the acceptable trade-off between precaution and protection. Again, an aggregation of individual preferences about the strictness of the rule. Now, we also have the reverse case with H.L.A. insurance. The opposite story is there. So at first, there was pretty much the industry was basically a check the boxes and you're good, circulate handbook, basically write anti-harassment policies and so on. After Me Too, insurers have come to realize there's a great paper by Erin Meyers and Johnny Hirsch that delves into this industry, Cornell Law Review, I think 2022. Forgive me if I'm misreferencing it, but after Me Too, many carriers left the markets. Many carriers have come to realize that their norm, right? Their previously adhered to rule was way too lenient, was way too lax, and doesn't allow them to profit as insurers. So they those who stayed, insurers that didn't left the market, specifically the entertainment market with H.L.A. insurance, I'm sorry, simply sets stricter coverage requirements. So again, we began with the drive 50 miles per hour, it's okay, nothing's going to happen. But slowly, we converge into a stricter equilibrium where that again reflects the riskiness, the actual risk that the individual creates, that the policyholders creates, and their expected losses, and the market converges into a more manageable rule that also responsive to the risk created, not only to the precautions required by the policyholder. Okay, so basically, so this was an overview of our positive argument. Here we address three, I believe, potential objections. The first possible objections that immediately comes to mind, at least to me, is that how can you say that insurance secures acceptance if no one ever reads insurance policies? Because how can we say that we argue that insurance becomes at least somewhat responsive to citizens, to the relevant population, but no one here, not maybe here will make an exception, but generally no one reads insurance policies, right? And sometimes not even lawyers. And the real question here is, how can we say that this document is somehow responsive to preference? We have several responses. Not sure that you'll be persuaded by them, but I think they're worth putting forward. The first is that no one reads zoning laws either. No one reads many laws. It doesn't mean that these laws doesn't matter normatively or jurisprudentially. And it doesn't mean in Hartian terms that there is no acceptance in its broader sense. This is why we first talked about the broader sense of acceptance. And the more important point here is that subjects have, albeit indirect, but genuine ability to influence the concretization that emerges. At least in the broadest term, so in the examples we discussed above, the insurance market was actually responsive to collective preferences if they are substantial enough. So this is more like the point. Our point is that it reminisces a legislative process more than it comes close to the to Austin's gunman writ large. A second possible objection is about opportunistic behavior. We're talking about this more a cynical view of, it's insurance. They care about their bottom line. They care about maximizing profits. Come on, how can you seriously talk about insurance as the epitome of direct democracy? Insurers might want to, they might want to actually use vagueness as strategically. We observe it in practice. There's the famous Michel Broadman paper on contra preferentum, that it might not always deter them. The contrary, but setting that aside, we can see that sometimes there's surely an interest in ambiguity, but the thing is that when it comes to avoidance before the fact, okay, not only to reserve from the kind of litigation leverage after the realization of the risk, ambiguity also becomes extremely costly to insurance carriers. Now, this pertains to a broader debate on whether insurance actually wants, whether insurance carriers, do they want a more or less risky society? And there's a line of literature on the regulatory role of insurance and how they work to, how they work to guide and to regulate and to basically use basically deploy risk-reducing practices among insureds and among policyholders. This on the one hand. On the other hand, we have Aviv and H.L.A. who spoke about the dark side of insurance, that basically insurers actually, in the broadest sense, they still want to keep society sufficiently risky because this preserves this preserves demand for their product. And what we argue here is that this sort of discussion, sub-discussion in our paper is a reflection of a broader debate. We're oblivious to that debate. We're oblivious to that debate. We're agnostic in that regard. We do not make any decisive points here. We still believe that as long as you believe that insurance care about regulating ex ante, at least some of the behavior of insureds, and care about preventing some accidents ex ante, then there's room for concretization and rulification rather than, the use of ambiguity altogether. Here, the final point is about personalized insurance. There's growing literature. Omri Ben Shachar writes a lot about it. Also with Ariel Porad, they have a book together on personalized law. And if we are headed toward a world that uses really personalized data and big data in order to tailor insurance based on our skills and our claim history and our preferences and so on and so forth, so that there is no general rule, but rather there is Roy's rule and there is Meir's rules and there's Travis rules, and there are completely different rules that have nothing to do with each other. In that case, how can we argue that there is still a unified concept of a rule? So our response to that is, first, the law is sometimes contextual and individualized, right? We tend to discuss the reasonable doctor, and then the reasonable pilot, and then the criteria. Each criteria might be different in content, so this doesn't undermine the jurisprudential power of the law in its entirety. Now, what we have at this point, again, based on my knowledge, the state of the art of the industry, is that we have categorizations based on, riskiness, which is more reminiscent to contextual rules rather than, Roy's insurance per se or Peter's insurance per se, perhaps with some exceptions we can discuss momentarily in the Q&A. Again, under the current state of the world, premiums are of course personalized, but the rules that we care about, the other dimension, the second dimension of the price we pay for insurance, remain sufficiently general for our theory. Here's the caveat, though. If rules will become more and more personalized, this certainly, and our theory will certainly confront a major challenge, and it might cast doubt on our perspective more generally. And May, if you have anything to add at this point, if I fail to mention something, mainly legal theory.
Okay. I'll just say something about the last objections, but I'll keep it to the Q&A. I thought it was great. I have nothing to add.
Okay, so I think we can open the discussion for Q&A. I can see you all. Great, that's it.
So, if anyone would like to get on the queue, I'll keep a queue. You raise your hand or raise your actual, like in the Zoom, or actually raise your hand and say Tom Baker first. You're on mute, Tom.
First of all, it's super interesting. I'm thrilled to see political theorists engaging with insurance. So, but I have to. So I feel like you're doing this kind of in a way that and here we go all the way out, because this is not remotely a criticism. I feel like you're doing this kind of in the way that I started out doing insurance as governance, where in order to persuade people to think about it this way, you had to kind of act as if insurers were kind of doing this in a way that was conscious and goal-oriented and kind of socially responsible. And so as a result, a lot of people misread insurance as governance to be this thing that somehow through public policy we could direct. Whereas really what it meant was in a more sort of Foucault kind of idea that, yeah, insurers are governing us. That's true, but it's not as goal-oriented and directed and manageable and regulable as it seems. And so, of course, then, Ariel Parad and the Ronen come in and said the dark side of insurance and like, oh, you don't, and to which we respond, no, you don't really understand what we meant by insurance as governance. In other words, we're saying it's out there. We're not saying it's always good. We're just saying that it is a force on the social field. And so I like this a lot because it's sort of like in some ideal world where there's sort of not transaction costs and people can really figure things out, like that we can understand, insurance as a kind of political force. I mean, it's, I and but of course it's not so directable, right? I mean, it's so anyway, I mean, that's a comment. That's more than a question. So then a question that I have is how important to you is this liability insurance versus first-party insurance distinction? Because it seems to me that where most of the places where we've actually can feel pretty confident that they're doing this governing thing, whether you want to call it political or whatever, seem to be in first party. Like Dan Schwartz has this really great article with his colleague Amy Monahan where they go through the rulification of the medical necessity, of the medically necessary standard in health insurance, which, by the way, you should totally read. And high-end commercial property insurers are almost like safety consultants to their customers. But those are first party. Those are where we're doing things, and even the cyber example, the big money in cyber, my understanding anyway, is really first party losses. It's not that there's not liability losses, but because yeah, there's business interruption, you got to replace the computer stuff. Like, for the liability, yeah, you have to sign up people for privacy monitoring for you. It's not that expensive. And so even that example is at least as much first party as third party. And so it's a question, like, does this necessarily have to be about liability, or can it be, because, zoning laws are about how I do my stuff. So maybe it doesn't have to be like, anyway, that's a long-winded comment and then a question.
Meir, you want to jump in or I'll start? Okay, so thanks, Tom. Just a thought on why liability insurance. Here's my intuitive reaction. In health insurance, there is no standard that needs to be clarified. I have the interest, I can hire you as an insurer, and I can also hire you as a teacher, as a mentor. You can guide me, right? But it has nothing. It has nothing to do with clarifying the relevant standards, my exposure to law. Right? I mean, maybe I'm wrong. And again,
it's about what's medically necessary, which is not about law. I agree with that.
Exactly.
Unless there were some law that says you're entitled to medically necessary. Yeah.
Precisely. So, and in this regard, and perhaps you should highlight this move, but yeah, I want you to guide me about what is medically necessary. The same way with liability insurance, and especially when there is a ubiquitous use of standards, that I want you to guide me about what the law is. What does it mean driving, reasonably? What it means. And when I ask what it means, and this is where our analysis stands, where you are guiding me about, here's what it means. It means drive, 30 miles per hour or whatnot. Again, my intuition, but if there's any possibility of extending the theory to first party, I'll be thrilled if you have. further thoughts on that? Great to see you, Tom, as well. Thanks for coming.
So I may take moderator's privilege to go next. So anyway, I love the like big think of this paper, the ambition of it, and the bridging the gap between political theory and insurance. So to go in more the direction of political theory, it seems like from my read of it that a lot of work is getting done in the paper by this connection that you're making between markets and democracy. So as I understand the argument, it goes something like insurance converts standards into rules. It does through markets, which are democratic in some way, and therefore it's legitimate. And so that I think it's the third step, that like markets are democratic, is the one I want to problematize. And so I mean, as you know, like in political theory, there's a lot of work done on distinguishing markets from democracy. And so, to like the Hirschman thing is like markets are characterized by exit. They're voluntary, they make for Pareto improvements, but they tolerate significant imbalances in power, right? Like that one party can have a lot more leverage than the other, and markets are fine with that. Whereas democracy is, in Hirschman's words, a voice. It can justify coercive power that affects non-Pareto improving redistributions. And it has a commitment to a certain type of formal equality that's not present in markets. So there's just basic distinctions between these two things as sort of like modalities of cooperation or whatever you want to call it. And so it seems to me what you need, and those distinctions, are kind of present in the heads of a lot of people. And so I think that a lot of readers will, like me, resist the sort of quick elision between the two. And so what I think you need is a theory of how markets and democracy relate. And you can think of two possible theories. Like one would be like Waltzer's spheres of justice theory, which is to say that like these things are separate, they should be separate. If they kind of overlap and bleed into each other, that's a problem. Or you could kind of side with Hayek or someone who's like, no, markets and democracy, they work hand in hand. They're sympathetic. They're doing fundamentally the same thing. But you need something there, I think, for this paper to really do what you want it to do. Question. That's more of a comment, but yeah.
If I can jump in, so my question was related, and so I think it fits well. So I think that so the mechanism you describe, right? Like there's this intuition that we're using this kind of democratic process to transform a standard into a rule. But was the standard not itself generated by a quite literally democratic process? Like these are policymaker decisions. They are responsible to the public. They decided to write a standard. And so in some way you could, I mean, if you wanted to kind of go for it, you could say, well, actually, insurance in this way subverts the will of the public because the public, expressed through their representatives, wanted a standard, and now it's being converted away through another process. And so I kind of wanted to push on that angle as well.
Can I jump on that? That's okay. Yeah, thanks. So these are great questions, I think. I'll get to Travis's in a second. I just wanted to thank you, Andrew, for this one. I think that my intuition here, and please Ray, jump in and correct me if you think otherwise. I think that what we're trying to say is that one should distinguish between standards as, let's say, legislative default and standards as what we can think of as a conscious democratic move. And what we mean by that is that I think at some point in the paper we try and reference Jeremy Waldron, who speaks about the importance actually of open-ended norms, right? Sometimes we don't want people to know precisely where they stand. We don't want the officer with the whatever baton or I don't know, insert cruel mechanism here to know how close they come to torture. And Waldron even gives another, perhaps more provocative example, right? We don't want a person to wittingly think, okay, how much more coercion can I apply before what I'm doing is rape? So surely there are cases where the democratic decision wittingly adopts a standard, whereas it also rejects thereby rulification. But we think that there are certainly also cases, following Hart's analysis, that these decisions are not really fully democratically. It's not that they're not democratic decisions, of course they are, but I think that it is plausible to think that the legislature adopted a certain compromise between how costly it is, or it will be, to adopt a crisp, clear, bright line rule versus, this is the best we came up with. And to support this line of or this second side of the distinction, we can see that later on what courts, what administrators, what agencies do is precisely concretize. So no one, I think, thinks that in all cases, and we certainly don't argue, and if we are read this way, Andrew, we should definitely correct our the way we write, but we don't think that necessarily whenever a legislature enacts a standard, they want the standard. Sometimes they just make do with costs. So that, I think, is the way I would respond to your question. Now, going back to Travis's, I think you're absolutely right that we need to do a better job of fleshing out precisely how we view. I would say the interaction between market and democracy. Now, you mentioned the voice, exit, and so on, and I agree. I think that, at least personally, and I think we should give it more thought, but top of my head, I would say that I think what we're trying to show is exactly this sort of complementary interaction between the two fields, right? So similarly, this is why I began my answer to Andrew with the distinction between situations wherein the legislature wittingly and consciously adopts a standard because it wants a standard and not a rule, and those wherein it's more of a default, of a compromise given costs and so on. So I think that what I would want to say is that perhaps not as strongly that the market is democratic, but it certainly has, in these situations that I just distinguished, a democratic enhancement function. This is, I think, how I would put it. Because what happens is that you have an unofficial, or at least a preceding informal decision, which we think at least comes close to this sort of pushing and pulling between subjects and norm setters, which again brings us closer to democratic ideals. But I certainly accept your remark that we should do a better job of conceptualizing this. This is just top of my head. Rory, please jump in if you have anything. Go ahead.
No, and I completely agree, Travis. And by the way, these are like 2 or 3 great references, I think. And my intuition is that we already have a theory. We, not Meir and I, we as legal academics, we have a theory that connects markets with democracy. It's called the social choice theory, and actually we allude to that throughout. I mean, it's right there, preference aggregation, and this might be another way of thinking how whether markets actually aggregate preferences. And but again, point taken, and we'll definitely think it through. About Andrew's point, I will say this: I completely agree with May. I think that there are 2 main ways to look at the use of standards. Now, the first is sort of a political economy style, where we say we have this lawmaker. He is tired. He just wants to get back home and watch the game. So he punts. He writes drive reasonably, and then let courts handle that later. I don't want to deal now with what is actually the optimal speed level. Give me a break, come on. And that's the first point. And if this is true, then insurance basically steps in and fulfills sort of the role of a benevolent lawmaker, instead of the lazy, the strategic one, the opportunistic one. But the more profound point here is this: what Meir alluded to. This is basically the Lewis Kaplan argument, is that sometimes standards are inevitable. they're not because lawmakers are lazy or not because they just can't. They don't have the means nor the ability uh, to walk through, the data and come up with the optimal solution. But insurance and insurers have the monetary incentives at the very least to do so. So I would say that you may say that the legislator is either benevolent or opportunistic. If opportunistic, then great. Insurers are insurance substitute for the legislator. However, even if the legislature is benevolent, there would inevitably remain some standards, and therefore, insurance are perform a complementary role. That's how I would put it.
Great. Ian Russell.
Hi there. Yeah, my name's Ian. I'm a student here at UConn in the insurance law seminar, and my question's at least thematically very similar to the last couple, which is that as I read your paper, I see it as primarily looking at how the law regulates the behavior of the policyholder or of the claimant, and then insurance kind of rulifies those standards. So, for example, the law of premises liability says property owner take reasonable precautions to keep your property safe. And then the insurance company says, well, that means you need to do X, Y, Z to keep your property safe. But there's a whole other dimension where the law actually directly regulates the insurance company itself and says, hey, insurer, here are the kinds of policies you are and are not allowed to offer. Here's the minimum coverage you have to provide. Here are some rules around your interaction with your policyholder and so on. And that really complicates the picture, I think, of this interplay between the democratic process and the role of insurance. So how do you see that the legislature acting on the insurance company as either supporting or undermining or otherwise qualifying your thesis here?
We need to save something for our next project. Yeah, come on. We can't do everything here. No. I'm joking. Here's my intuitive reaction. Then May will say something more, intelligent. So it depends, and it could work either way. So the obvious example is contra preferentum, right? When you have, suppose that you have that ambiguous clauses are interpreted against the drafter. This basically forces the insurance carrier to concretize the rule, right? To concretize, the standard into a rule, right? So this is one example. Again, whether the insurance carrier ultimately does so or not, on refer to Michel Boardman, 2006, fantastic paper. But here's one thing. The other thing is that I mean, intuitively, I would say that it could go in the other direction. I don't have examples off the top of my head, right? But sure. I mean, point taken. I will also say that there are rules regulating, like meta rules regulating the democratic process itself, which it might be interesting to entertain the analogies of I don't know the rules, the procedures governing the legislative process, and how they are somehow could somehow be analogized to the rules governing insurance contracts. So again, my 2 cents. I think it's a great point, but we should think on it further. Mayor?
No, I would settle with that. I think it's a great point. I think it's a wrinkle we should certainly iron, but I agree.
Great. Mark Mayerson and then Peter Siegelman.
Hi. This is a beautiful, elegant paper. I really enjoyed it. I wonder though, does a founder on reality maybe? And I my feeling is in part that cyber insurance and EPLI insurance are really unique because they're neoliberal creations and statutory liabilities in effect, where we then can hire insurance as coach or whatever. And the vast failure or disconnect would be products liability. And I'm going to post in the chat one of my favorite cases. I also taught this this week, so it's top of mind. But it would be very hard to think that products liability is regulated via insurance, except for providing mechanisms of compensation or not. So the first part, the analysis being focused on first party, these statutory things all work, but then as we generalize to the liability system, I think there's more of a disconnect.
Okay, it's interesting. If you could post it, I'll take a look. By the way, intuitively, product liability, and again, Tom could correct me if I'm wrong. I think that product liability is an area where insurance, at least as a regulator, functions. I mean, I wouldn't say perfectly, but functions quite well. Disciplining and devising like concrete rules, standards, but at least behavioral guidelines based on Ben Shahar and Logg's paper. But I will revisit it and definitely up. And whether these examples are anecdotal, we use them primarily in order to demonstrate the two extremes. First, how a too lenient rule gradually converges into equilibrium, and how the industry converges from a too lenient or a too strict rule into some equilibrium. I think there are other examples I had in mind. Tax insurance, maybe, or tax law is and if you have others, we'd love to hear. But again, I'll take a look. I'll take it for your word for that.
Can I follow up quickly, Mark? Because I think it's a good and important point. I would kindly ask you if you think that there is something specific to product liability that is problematic for our account, or is the point rather that, look, here's a major area in insurance that your theory doesn't really cover for?
Both. Because since the liability ends up being, in fact, standard based, right? Risk, benefit, utility, often. But the insurance doesn't provide guidance for the manufacturer about what they should be doing or not, and the way that insurance in turns compensates and determines which are compensable products liability matters and which are uncompensable under insurance is not defensible from a moral perspective. You can kind of run numbers as to understand why they do certain things in a particular way. But given in the US, the incredible size of product liability verdicts, that is a driver for insurers, it's routinely a major loss line for the insurers. It's an unprofitable line for insurers. I just think this is a very challenging part of example to your argument, though, as I said, I think the argument is beautiful and works on its own terms, and I wish reality mapped better, perhaps.
Yeah, I can't even. No, thank you. Thanks. That's really helpful. I mean, I don't know enough about product liability, but I'll certainly think more about it. And Roy, if you have any insights, please.
I'll just comment on. Oh, I see, Peter. Just a remark on David. Just saw David's comment on the reinsurance. I think that it pertains to Ian's question on rules about insurance, maybe how insurers interact with each other, maybe something there, but it's a nice avenue to explore. We should dedicate more thought. No, I don't have any intuitive reaction, my way of saying.
Can I just say something which I think would be interesting? This is following up on Mark's comment. It would be interesting to know if, because the product liability insurance market's broken. And so it would be interesting to know that in areas where your theory better maps reality, is that mean that insurance markets are more likely? In other words, is your argument somehow related to the idea of insurability? In other words, are things insurable the more that insurers can play the role that you're positing that they're, and to me, that would be a really interesting question for you guys, for a rabbit hole for you guys to go down.
Very, very interesting.
And I bet Mark agrees.
Very interesting.
Always.
We should think. Yeah.
Peter, last question.
Yeah, it looks like it's after 5 though, so maybe we should just kill it. I sent some comments. I mean, basically, my quick question. So I know a little bit about H.L.A, and that was one of your examples. It seems to me that even in the recent versions, and I know less about that, that what liability insurers want to do is make sure that their insureds don't have to pay for stuff. That is, it's what they have an incentive to do is make sure that you're bulletproof, that you've checked all the boxes that courts are going to look at to assign liability. And if that's true, and there's plenty of evidence that that used to be true, they use the phrase like bulletproof your operations and stuff like that. They don't want to reduce harm. They want to reduce liability that they're going to be responsible for. That does not seem like it's very democratic to me. That cannot be what the legislature meant when they passed Title VII is, oh, let's just have some stuff that's checklist that means that employers can do whatever they want to and harass people and not be responsible. It's that H.L.A is telling employers how not to comply with the spirit of the law while complying with the letter of the law, standards or rules notwithstanding. So I think that's not such a great example for you, or at least I think it's a more complicated one than you make out.
Can I jump in on that? I think it's a really strong point, actually, and that's an objection we should consider, I think, much more seriously. It seems to me to echo, correct me if I'm mistaken, Peter, the opportunistic point. But it's not exactly the opportunistic point because it also has the twist of the distinction between the letter of the law and the spirit of the law. So I like it very much. I think it's a strong objection. Top of my mind, maybe I would say that how shall I put it? I want to say that so firstly, we might think, in a more extended time frame, perhaps that this changes legislative practice. So that might be one avenue of dealing with the complexity. But another would probably be to, at least to an extent, bite the bullet and say, look, you wanted to achieve X, quasi-legislature. What you actually achieved through the various concretizations of, both formal and informal actors and so on, is Y. And the Y might be more, or we would want to say that it's more responsive to actual preferences and so on. Of course, we need to overcome the hurdle of showing that it is actually a democracy-enhancing mechanism. But to the extent that we can do that, perhaps we can at least mitigate the objection. Does that make sense? But again, I think it is a powerful objection. We need to reckon with that, for sure.